Be seated, and good afternoon, folks.
Good afternoon, Judge.
All right. The first matter before the afternoon is docket number 18 to 538. This is Campos, City of Natchitoches, et al. Counsel for the city, make an appearance, please.
Of the City of Natchitoches.
All right. Thank you very much, sir, and Mr. Campos, if you could introduce yourself.
Yes, sir, my name is Rogelio Campos. I'm running pro se here.
Thank you very much, Mr. Campos. And you can be seated at this time. Just make sure, sir, your microphone is on. All right. Very good. Reminder to both participants in today's hearings, and to myself, we are joined and appreciative of the court reporter services. Thank you very much. We all need to speak slowly, carefully so that we can be recorded. I'll be the first one to mess up. So just hang in there and try and assist me with remembering, as I will do the same for you. Folks, we are here for the purpose of taking evidence regarding document number 20, that is the motion for temporary injunction which was filed by the plaintiff, Mr. Campos. We are, in addition, here to discuss anything else that might be pertinent at this point. But to be clear, this is an evidentiary proceeding. We are not here to take argument or evidence regarding document number 34, which is the motion to dismiss. I have received that motion and it has been set for briefing, but it's not ripe for consideration or discussion at this point. I will apprise both parties that the court is very familiar both with the initial filing documents, the amended complaint, and all documents underlying the motion for preliminary injunction. So in English, I've read the motion and all additional briefing regarding the motion. I've also taken a look at all exhibits and evidence filed, including 2 videos that were provided to me, one by each side, I believe. I've reviewed body cam footage from an April 2017 incident, as well as an August of 2018 incident, and I'm familiar with the content of those videos. What I'll tell you both is that I'm happy to review any portion of those videos that either of you feel might be beneficial. But for purposes of evidence, I am familiar with the content of the videos. Final note before we get started. I really don't need any recitation of legal argument regarding the motion for preliminary injunction. The truth is that I've reviewed the briefs very carefully. If you have any additional legal argument that was not contained in your briefing, I'm very happy to hear that argument, but there is no need to rehash anything that you've filed because, again, I did very carefully review everything before we convened here today. So that's what I have to say by way of introduction. For purposes of substantive law underlying today's proceeding, of course we are here to again take evidence regarding a preliminary injunction pursuant to Federal Rule of Civil Procedure 65. The court notes for purposes of the record that as always, the issuance of a preliminary injunction will be an issue that the court considers carefully and with the degree of caution that is warranted by the preliminary injunction procedure. The court notes, as always, that a preliminary injunction is, of course, an extraordinary and drastic remedy, and is only to be issued if the movement shows by a clear burden of persuasion that the issuance of the injunction is necessary and warranted by law. The 4 factors underlying the preliminary injunction procedure should be noted at the outset, and this is what we're really here to take evidence about, folks. First of all, the movement, which in this case is Mr. Campos, has the burden of establishing, first, a substantial likelihood of success on the merits. Second, a substantial threat that failure to grant the injunction will result in irreparable injury. Third, that the threatened injury outweighs any damage that the injunction will cause to the adverse party, and, finally, that the injunction will not have an adverse effect on the public interest. In light of those four factors, the court will make its determination regarding the propriety of a preliminary injunction after today's hearing. I will make my ruling in writing, and that ruling will follow today's hearing, and will consider any additional evidence presented. And to be clear, the movement has the burden of establishing each of those four factors or elements. And to the extent that the movement fails to establish any one of those four factors, the movement's motion for preliminary injunction should fail. Mr. Campos, do you have any questions or anything else that we should say before we get started with evidence, sir?
Yes, sir, on my memorandum to review, memorandum to support my injunction.
Yes, sir.
I did mention something about Rule 62, I believe, which would, it's not totally clear to me, but it does review the case, but the case is really related to the legitimacy, the legalness of the statute that is at the core of this injunction. Will there be an opportunity to argue that to see if it does comply with the constitutional regulations?
Sure. I don't know if you're referencing the correct rule, Mr. Campos. You may be thinking of Rule 65 still. Rule 62 pertains to a stay of proceedings to enforce a judgment, and is very likely not the rule that you're discussing. I think you're probably talking about Rule 65. But in any event, I will give you an opportunity to make comments about that if you wish.
Okay.
Anything else preliminarily?
No, sir.
Okay. Mr. Corkern, anything we need to do by way of introduction?
No, sir.
So, Mr. Campos, do you have an idea of how you would like to proceed in offering any evidence? Very good. So that brings us to the evidentiary portion of our festivities. Mr. Campos, you are what is called the movement in the case before the court today. That means that you have the burden of proof and persuasion as to the motion for preliminary injunction. That means that you get to go first and last. So this is the opportunity that you have to present to the court any evidence, and I'll give you a chance to make argument later about your motion for preliminary injunction. Evidence can take course, physical evidence, but it can also evidence or any testimony that you wish to your own testimony if you wish to do that. So, Mr. Campos, do you have an idea of how you would like to proceed in offering any evidence?
Well, I think I'll just start off with the legal standard that you mention, the 4 points that justify a temporary injunction.
Yes, sir.
Starting off with the plaintiff likely to succeed occasions, that they're the court that my case or this case will succeed on its merits. We are talking about referring to an unconstitutional ordinance that is at the core of a probable cause for an arrest. On the merits, I have addressed that on various both I believe in my original motion, I believe is sufficient evidence that's been presented too, and so as I mentioned earlier, if I can go and argue about the constitutionality of this ordinance, that would help explain the success and the merits that I'm talking about.
Well, what we need to do, and let's make sure that Madam Court Reporter can catch up here, since I'm interrupting you. What we need to do is be sure that we're speaking the same language here, Mr. Campos. You're in an odd position here representing yourself, in the sense that you may both have evidence to offer me in the form of your own thoughts and testimony about this situation. That is one thing. You're also representing yourself, so acting as your own attorney, for lack of a better phrase. And because that is true, you may have legal argument for me as well. Those are two different things. Do you understand the difference between those two things, sir?
I think so. Maybe you could re-summarize that.
Sure. If you wish to testify under oath.
Correct.
about some of the events that are underlying your motion for preliminary injunction, you can do that, and that is a form of evidence. The court considers that in a different way than it has to consider your argument. So, in other words, your independent thoughts about the law underlying your motion for preliminary injunction, those are two different things. What I want to do right now is consider any evidence that you might have to offer. So I don't see any other witnesses in the courtroom, but, for example, you might have brought someone here with you to testify about something that happened. You would testify in this situation in the same manner if you wished to do that. You might have documents for me. I can't remember if one of the videos actually came from you or not. But if one of the videos came from you, you would need to offer that into evidence. Do you see the difference there?
Yes, sir, I do.
Okay. So we need to stick to evidence at this point. What you're telling me now is really legal argument, and we can certainly talk about that later. But if you have evidence at this point, that's what I need to hear. So let's start, and let me see if I can help you out a little bit and sort of moving things forward. Did either of the videos that I have referenced come from you? Did you offer a body cam video?
Yes, I did.
Okay.
With the original complaint.
Okay. And, Madam Deputy, do we have those exhibits physically in the courtroom today?
Yes, sir.
All right. If you wouldn't mind, Madam Deputy, let me take a look at those. Okay. So, Mr. Campos, I've received a video that is a body cam video from an incident that occurred on April 14th of 2017. Is that the video that you offered?
Yes, sir, it is.
All right. Very good. So what I'm going to do is have my courtroom deputy here bring you this video, and we're going to see if this is the one that you offered. And then we'll see if it's going to be admitted into evidence. Okay.
Yes, it is.
Okay. So, Mr. Campos, is this a video that you would like to formally offer into evidence to the court so that I can consider it for purposes of your motion?
Yes, sir, I would.
All right. And so we're going to assist you here in marking that exhibit, now that you have authenticated it and told me that that's the right one. And, Madam Deputy, this is going to be plaintiff's. Thank you very much. Okay. Mr. Corkern, do you have any objection to the admission of Plaintiff's Exhibit 1 into evidence, sir?
I have no objection, Your Honor. I like to inquire. Does that video contain the stop on April 14th and the incident on April 15th?
It's solely on the 14th, I believe.
And, Mr. Corkern, I have reviewed the video, and the Exhibit 1 does not contain any body cam footage from April 15th, it's only the stop and arrest on April 14th.
No objection, Your Honor.
All right. Thank you, Mr. Corkern. Without objection, then, Mr. Campos, I'm going to accept Exhibit 1 into evidence. And I've already advised you that I have reviewed Exhibit 1 very carefully, so I'm familiar with its contents. So are you starting to see how this works now? We've got to focus on evidence at this point, and then we'll talk about legal argument a little bit later. Do you have any documents or anything else that you would need to offer to me at this point?
No.
All right. And so the only other thing that I can ask you is if you have any witnesses to offer, either yourself or somebody else?
No, sir, I don't.
Okay. Do you wish to testify under oath here today about anything that you think is important in terms of the motion for preliminary injunction? And let me advise you of this. You don't have to testify at all right? You can simply argue your motion if you wish to do that, but it's an opportunity that you can avail yourself of if you wish.
I would like to get back to the evidence that was just submitted into the record, sir. The first 5-10 minutes shows basically the core complaint that's before the court.
Yes, sir.
It has me being stopped and being arrested, and no probable cause being asserted, and then the probable cause being developed within the next 5-10 minutes. The probable cause is the ordinance that is in question today, which is disturbing the peace, 10-58. So within the first 10 minutes, we can see how exactly the tape was used, or how that ordinance was misused to make a false arrest. And why applying for a temporary injunction from this court so that it doesn't happen again.
Okay. I appreciate that, Mr. Campos. All right. Do you intend to offer other witnesses or any other testimony during today's hearing, sir?
No, sir.
Okay. I appreciate it, Mr. Campos. Then, Mr. Corkern, that brings us to your side of the case. The pendency of the motion, of course, you have the opportunity to offer any evidence for purposes of the record that you wish to offer. Go ahead, sir.
Judge, I was under the impression that Mr. Campos's request for an injunction was broader in scope than simply the issue of the ordinance under which he was arrested. I thought he was requesting an injunction because he has alleged that the city police are constantly harassing him. And if that's the case, then I do have evidence I want to put on. With regards to the ordinance itself, when this case came up and I reviewed the ordinance, and I subsequently determined that I agree, I think the section of the ordinance under which he was charged is unconstitutionally vague, and I so advised Chief Dove. And Chief Dove has recently sent out I'm not sure. What do you call it, Chief, when you send it out and they have to acknowledge that they received it?
An email. It was a read receipt.
A read receipt email telling them do not use the city ordinance anymore. If any arrests are made based upon disturbing the peace, it's to be done under the state ordinance. At least that's what my letter to the chief said.
And it's your appreciation that the chief submitted an email to the officers. Is that what you're telling me?
That's correct.
Okay.
That's correct, and I'll have testimony to that. But if that's the only issue, then I can stop. If the issue is, which I thought was the issue, that the city be enjoined, the city police department be enjoined from harassing Mr. Campos, then I have evidence to put on because he has alleged at various times that we continually harass him. And if that's still his allegation, and if he's looking for an injunction against that, then I'll have evidence I would like to put on.
It has been my appreciation that you are. It has been. Okay. 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 I appreciate that, Mr. Corkern. And, Mr. Campos, I'm going to turn to you, but let me explain to you what my understanding of your pleadings has been. It has been my appreciation that you are requesting a preliminary injunction which would prohibit the enforcement of the city ordinance. And that in support of your request for an injunction, you have alleged that you are being subjected to harassment. But that you have not requested that this court enjoin the Natchitoches Police Department from harassing you. I have not read your pleadings to be a request of that nature. I think Mr. Corkern is fairly bringing up an important point. We have to establish with exactitude what you are asking this court to do. And once we do establish that, then we can determine how to appropriately proceed. But what I'm telling you is this. I haven't read your pleadings, up to this point, to be a request for an injunction to do anything outside of stop enforcement of the city ordinance. So I want you to tell me if I'm understanding your pleadings correctly.
Yes, sir, you're absolutely correct.
All right. So, Mr. Corkern, that being the case. Well, let me make sure, Mr. Campos. Is anything I'm asking you unclear? That was kind of a long-winded question. You understand my question?
Absolutely.
Okay. So what you're looking for this court to do is enjoin enforcement of the city ordinance, and that's it?
Well, and apply an injunction against it.
Right.
For my benefit and for the benefits for our citizens.
Okay.
It's an illegal ordinance, and I want the court to declare that.
Okay.
And then apply the injunction against it.
All right. Mr. Corkern, that's clear to me. Do you have any need to clarify what the plaintiff is looking for, any further than that?
No, sir.
All right. So that being true, it sounds to me like we have sort of the area of prospective disagreement at least clear. We're here to talk about the ordinance and the ordinance only. So that being true, Mr. Corkern, what's your position with regard to any evidence you wish to put on? Thank you, Mr. Corkern. Mr. Campos, this is an opportunity to conduct what is called cross-examination for you. I'm sure you've got some idea of what that is. You have the right to ask Chief Dove questions regarding the questions that were just asked of him. If you do have questions for him, just please make sure and keep them in the form of an inquiry, not a statement. Anytime you're ready, cross-examination, Sir Mickey Dove, was previously sworn by the courtroom deputy.
Mr. Chief Dove, is this the first time that you become aware that this ordinance is unconstitutional?
Yes, sir, it is.
Who developed, who wrote this constitutional ordinance, I mean, this ordinance, I'm sorry.
Who wrote this ordinance?
Right.
Mr. Campos, I don't know. When I looked at the city ordinance in the book today, as a matter of fact, I saw where this was written. It looked like, in 1950.
1950?
I wasn't nowhere around back then.
Would you conjure a guess that a lot of people have been arrested under this ordinance?
I have no idea, sir, I really don't know.
You've been with the Natchitoches Police Department, 29 years, and you have no idea.
Generally, when we make arrest on this, it was under disturbing the peace under state statute. So I do not know how many have been arrested under this city ordinance. No, sir.
Did you make a direct decision to apply this ordinance against me?
No, sir.
Okay. Were you aware that the police officers were using this ordinance against me?
Yes, sir.
Were you aware at the time of the arrest?
Somewhere thereabouts or right after it. You may have already been cuffed. I don't remember.
Right, okay.
What the timestamp was.
So that would have been prior to them coming up with a probable cause.
No, sir, you would have been arrested. If you're in contact with headquarters?
Correct.
Yes, sir, they did.
So they double-check with the headquarters to make sure that they're doing the right thing?
Well, I'm going to object to the form of the question, because that's not the question you asked him earlier. I mean, when they make the stop, they inform dispatch that they're making a stop.
Correct.
And that's for safety reasons.
Correct.
That doesn't mean that they tell dispatch or anybody else, "We're stopping Mr. Campos, and this is what's happening, and what do you think about it?"
Let's see if I can help out here. Chief Dove, if you would, why don't you walk us through the routine procedure in terms of communication between your patrol officers and anyone at dispatch or headquarters?
They will get out on the radio when they're either making a traffic stop or arriving on the scene of a complaint. They let them know that they are 1097, which means they are there. They'll go through whatever investigatory issues they have to go through at the time. If an arrest is made, they get on the radio and let them know they are 1015, which means somebody is in custody. They don't get into the charges with dispatchers. They don't get into what's going on. They just say 1015.
And that is the customary procedure?
Yes, sir, it is.
Okay. I appreciate that. All right. Mr. Campos, you can go ahead, sir.
In this process of making arrest, what evidentiary records are you required to keep?
An arrest report.
I mean, in terms of video and audio record. A. We keep it until it goes to court. Yes, sir. In this particular case, Sergeant Rochelle has, "I'm sorry, that's a statement." Is there any reason why the body cam would be flicked on and off during an arrest?
During an arrest?
I can't convince Mr. Your Honor, I'm going to make an objection only because this is going to come up in another context. We have produced an awful lot of stuff in response to a request for production of documents. We've had a conference. I can't convince Mr. Campos that we have provided him with all that we have. And he has informed me that he is filing with the court a motion to compel. And so what he is doing now is deposing Chief Dove on issues related to the motion to compel, and that is whether or not we have recordings and how long do we keep them, etc. It really has nothing to do with this injunction.
Mr. Campos, are you asking the chief what the procedure was on April 14th, or what the procedure is generally?
I'm asking what the procedure was on the 14th, sir, because I was arrested, and it took 5 to 10 minutes before they could come up with a probable cause, and by all signs, they were conferring with headquarters to determine what the probable cause was, which resulted to be the subject matter of this injunction hearing, the disturbing the peace. 10 to 58. And so I'm curious how that ordinance suddenly appeared and applied to me.
So why are we asking the chief about flicking a camera on and off?
Because of discovery and because of the responses that the opposition has provided in the discovery shows that.
I'm going to allow you to question the chief regarding the April 14th incident and that incident only. So if you have a question about what occurred there.
Okay.
That is the subject of your injunction, and so we're going to allow that inquiry. Go ahead, sir.
Okay.
So for purposes of the record, the objection is technically granted in part and overruled in part.
Would there be any reason why the supervisor in charge of that arrest, Mr. Sergeant Stephen Rachal, Jr., Stephen Lester Rachal, Jr., would have turned on and turned off his body cam recorder during the event?
I do not know of a reason, no, sir.
Are you aware that he did?
No, sir.
Okay. I have no further questions.
All right. Thank you, Mr. Campos. Any redirect examination, Mr. Corkern?
No, Judge.
Okay. Very good. Okay, gentlemen, then that simply brings us to the point at which I will be happy to accept any legal argument about what we are to do at this point with the request for preliminary injunction. Mr. Campos, this is that opportunity that I was telling you about. At this point, you can give me any legal argument that you wish to give me about what has transpired here underlying your request for an injunction. Go ahead, sir.
Well, opposing counsel's already acknowledged that the statute is perceived and has been established as unconstitutional. That was a major gesture on my part today. Having said that, then what remains is the validity of obtaining a temporary injunction or a declarative relief or a permanent injunction of some sort. I have a question to the court, sir. Are we prepared to establish that this ordinance is unconstitutional?
Well, it depends on what you mean by establish. It's an uncontested point. If you mean I'm prepared to rule on it.
Correct.
In some formal way, as I said, whatever I do is going to be in writing, so it will follow this hearing. But what I will tell you is the defense is not contesting your position there.
Okay.
So that gives you a good chance of on that particular point, if that makes succeeding sense.
Then as a question of law, once that's done, why would I need a temporary injunction for a null and void law?
Well, that's a pretty good question. And I imagine we're going to hear from Mr. Corkern about what the city intends to do going forward with regard to this particular ordinance. Chief Dove has already assured you that his officers are not enforcing subsection of 10 to 58. That appears to be, technically speaking, the relief that you're asking for.
Yes, sir, it is.
So there's a couple of different avenues that we can go through. Avenue number 1 is you could withdraw your motion for a preliminary injunction if you wish to do that. That's entirely up to you, if you wish to do that. But if you're satisfied with Chief Dove's representations and you don't feel that an injunction is warranted, you are welcome to at this point move to withdraw your motion for an injunction. And I'll hear from Mr. Corkern if he's okay with that. And if you do that, if I were to agree with you, then we would simply go to the next phase of the case. So, in other words, I would not issue an injunction because you're telling me you don't want one. It's up to you. I want you to be sure that it's optional. Option number 2 is y'all can submit to the record to me and I'll decide whether or not I think an injunction from this court is appropriate. I don't know of any other options. That seems to be where we are. Without an injunction, is there
Without an injunction, is there any legal basis to compel the city not to use this law? In other words,
legal basis?
Yes, sir, such as contempt of court.
No.
So an injunction is needed.
That's not for me to decide. The city is telling you that they are not enforcing the ordinance, but no higher authority has ordered the city not to do that. I imagine what we're about to hear from Mr. Corkern is the city is going to undertake some effort to revisit this ordinance and something along those lines. But I don't know that. The point is, your question is there a legal requirement that is imposed upon the city absent an injunction from a court? No, there is not.
Well, I believe, then, that an injunction is needed.
All right. Any additional argument?
Well, the legal standard are the 4 points that you mentioned earlier.
Yes, sir.
Which is the success of the merits, the likelihood to succeed on the merits. Now, is this in the merits of this particular injunction, or is it in the merits of the overall complaint?
The merits of the injunction are what is at issue here, so.
Okay. Well, I think that has pretty much been established. The city has conceded that the ordinance is unconstitutional, so the likelihood of succeeding on the merits of that particular issue has been established. That there is likely to suffer irreparable injury if temporary or permanent relief is denied. I have addressed that on various briefs, and I do have a few notes here that relate to that. There has been an ongoing threat of harassment because of this ordinance, and there's been transgressions that have evolved from this ordinance. The emotional trauma that we have suffered is not quantifiable and is really without adequate remedy at law. If you can't quantify it, how can you remedy it with law? The courts have found that the loss of freedom of expression has also been determined to be irreparable, and I have lost a lot of freedom that is protected by my first constitutional right related freedom of expression and photography, so that remains irreparable. The fourth police intrusion that we have talked, that I identified, that you have a tape, that's on record now, which was mentioned as police strangulator, has left scars both for my significant other and myself. The police come and go. We suffer post-traumatic stress. This is the fourth time that 4 units come to our house, banging on the door with no probable cause, no reasonable suspicion, just to harass. If you don't have probable cause or reasonable suspicion, they have no business there, and we told them that, and they don't leave. So once again, I'm still referring to the irreparable injuries, sir. Police have used this method constantly, causing this anxiety, this stress, this post-traumatic stress that continues on. We submitted an affidavit. It was not a notarized affidavit, but my significant other submitted it, of another situation related to photography, related to potentially being arrested for disturbing the peace at a restaurant. We're sitting there, and you know the details. I don't think evidence has been submitted other than an affidavit, but we're left with a ruined evening and the stress and the trauma that precedes that. So there is a lot of irreparable harm being done here. And then to make even matters worse, if they were to succeed with another arrest under this ordinance, there is a high likelihood that I may not be able to recover financially. There is a high likelihood that I would have to default in many ways, and maybe not even pursue my complaint. I would be in jail. How many times do I have to get arrested before my reputation as a professional engineer is ruined? In fact, it already has been, and it's part of my complaint. Certainly another arrest would not help that. The balance of equities, it's clearly what they have to suffer versus what I'm suffering, which is irreparable harm and because of the likelihood of success on the merits. The imbalance is a burden on me. The balance is that, the balance of equities that the defendant suffers pale to the irreparable damages that the plaintiff will suffer. So I'm suffering irreparable damages, they're suffering absolutely nothing. They have an unconstitutional law. Would an injunction serve the public interest? Of course it would. So many people have been arrested under this ordinance, they don't even know how many there are. When you compare the agony, the cost, the jail time of other citizens that have gone through what I've gone through, why wouldn't this be a great public interest? And so that covers the 4 points, sir, that is part of the legal standard for an injunction.
All right. I appreciate that argument, Mr. Campos. And Mr. Corkern, any argument from you, sir? Okay. Thank you very much. Chief, if you could sit tight. Mr. Campos, you do have the right to cross-examine the chief regarding these issues that we have just covered and no other issues. Do you have any questions for the chief?
Yes, I do.
All right.
Mr. Dove, is it against the law to take pictures under the circumstances hereby reported?
No, sir.
It's not against the law.
No, sir.
If it's not against the law, to respond to a situation that has.
Because we don't know what's. Mr. Campos. We have the complaint. Follow up to find out exactly what. Involved.
It's well documented herein, wire police dispatch not broken the law, happening at the time, from the citizen, and we it is, find out who is, the police blotter, sir. It's just a man taking pictures.
Yes. And we still follow up on every call.
To the point where you.
If needs be, yes, sir.
And what circumstances house?
The complaint filed by.
Even if no laws are broken.
Yes, sir. Again, we're investigating. We don't know what all is taking place until we get there. To go work for the police station?
To go work for the police station?
A Miss Sarah Dunn at one time did work for police records. She is no longer there.
Do you have an officer named Kaiser?
Kaiser? Go to their house? Do you need to go to somebody's? The citizen. You don't need probable cause or reasonable suspicion to someone's house? We need probable cause for an arrest, Mr. Campos, okay. Not to investigate. What about reasonable suspicion? Not to investigate. You don't? No, sir. Okay. Some of these individuals you mentioned, do they?
Correct.
Yes, we do have an Officer Kaiser.
Is he related to the woman that filed the complaint, first complaint, back in January?
Not.
Have an officer says no laws are broken yet, and then we have other officers that seem to take it as a federal offense.
Whom are you speaking of?
Regina Kaiser.
I don't know, sir. I honestly do not know if he is or.
Okay. Why is there a variation in your response, we?
What do you mean?
I think you mentioned an all-points bulletin, no? I believe the sergeant or somebody has mentioned that.
I think he's talking about the entry. Be on the lookout for the vehicle in Walgreens parking lot that was described.
So why the variation in response? I mean, you have some officers say no laws are broken. You have other officers that say, or all points bulletin, let's get this guy for taking pictures in a parking lot.
I object to the form of the question. There has never been anybody say let's get this guy. There was a complaint filed, because a guy was taking pictures in Walgreens of a lady, and she called in a complaint and gave the number, and they put out a bulletin to be on the lookout for this vehicle.
The objection is sustained. The question, Chief, that I think is appropriate to answer is why there might be a difference in responses according to the blotters that are in front of you.
We didn't know for sure who we were dealing with at the time. And when we get these allegations or this, or these concerns from these people, we like to know who it is in this car. I mean, we want to make sure that it is not somebody that is trying to look out for sex trafficking or human trafficking. We like to know who we're dealing with and what's taking place. We talk to the person driving the car if we can. And if everything seems on the up and up, everybody goes on about their business.
So if you know that it's me, does that make any difference in terms of the time, effort, and severity perceived by the police?
It all depends on the circumstances and what has taken place, Mr. Campos.
It's pretty. There's a pretty good pattern here of what's taking place.
Questions, Mr. Campos?
Sorry. Did you see a pattern from the police blotters of what has taken place?
I see a pattern of you taking a lot of pictures of people you don't know. Yes, sir.
Pictures of people in cars, or people? It just says people.
It just says people. And so cars aren't a part of them.
And so cars aren't a part of them?
I'm sure cars probably are.
Okay. Have you tried to determine whether it's people-oriented or car-oriented or circumstance-oriented?
Have we tried to determine how it's oriented? Q, the pattern,
The pattern, the MO, the tactics, or call it what you will.
Mr. Campos, I really have no idea why you do this. I can't. I wish I could explain. I do not know why you take all these pictures.
Do you have an assistant police chief?
Yes, sir, I do.
Is his name Winters?
Yes, sir, it is.
Okay. Did he provide you a meeting that we had before all of this happened?
Mr. Campos, we're starting to stray from the appropriate scope of this examination. You need to stick to what Mr. Corkern asked. Does this question have some relationship to Defense Exhibit 3, which seems to have been all Mr. Corkern was asking about?
Okay. The reason I asked, sir, is because he said he didn't have any idea why it was happening, any reason why I am taking pictures, and that particular meeting with Mr. Winters pretty much laid it all out.
Okay. Chief, who is Mr. Winters?
He is the Assistant Chief of Police. Judge.
Did you have a meeting with Mr. Winters about Mr. Campos's motivations for taking these photographs?
I do not recall that meeting.
All right. I think Mr. Campos is asking you, have you made any effort to determine why he takes these photographs that is independent of what we know from Defense Exhibit 3?
No, sir, I really do not have any idea. No, sir.
And have you taken investigative steps? Something along those lines, met with any folks or done anything else, to make that determination why Mr. Campos may be taking these photographs?
No, sir.
Okay. Mr. Campos, is that what you?
Yes, sir.
Trying to accomplish?
Thank you.
Okay.
I have no further questions.
All right. Any redirect examination? Mr. Corkern?
No, sir.